So, hello everyone. You are welcome to Law of Engineering Contracts. And we are going to start with capacity to contract. Right, so what's capacity to contract? What capacity to a contract means is trying to it's just like us trying to bring to existence the fact that there are some things that may hinder some people from being a part or from signing a contract, or even if they had signed, from being liable to a contract. And the reason why the law tries to captivate or try to protect this set of people is because of their vulnerability. They are vulnerable to those not in their category. And the category of people that the law is trying to protect under capacity to contract are infants, can call them children, insane people, people of unsound mind, drunkard, illiterate, and corporations. That means companies. All right, so looking at what I am sharing now, you will see that with contracts, like you have been taught earlier, is that the rule in contract is that when four things like offer, acceptance, consideration, and intention to create legal relations has been established or is in a contract, such a contract will be seen as valid. It will be seen as valid, and so parties will be binded by such contract. But then I am here to say that there are some other things that can affect contracts, or would I say there are some people that even when all these four elements of contract are in the contract that they have signed, such people may not be binded by such contract. And like I have itemized them: infants, insane persons, people of unsound mind, drunken persons, illiterate persons, and corporations. All right. So we look at that starting from the place of infant. Initially, an infant is anybody under the age of 21 years old. An infant is anybody under the age of 21 years old. And this was actually affirmed in a case between Labinjo and Abake, who was decided in 1974. So in this case, there's this young lady who was then 18 years old. He was involved in a contract with the claimant, Labinjo. And so she couldn't, she presumably bought items on credit. She's actually trading. She bought those items from the claimant, Mr. Labinjo, on credit. But after the purchase of the items, she couldn't pay her debt. So Labinjo sued Abake to court. And the decision of the court was that Abake, who was at the time when the contract took place, was 18 years. The court in its decision stated that Abake is not liable to that contract because she was still seen in the face of the law as an infant. This has been the case even before 1974. And so there are some contracts that would not be approved for people of this age to be involved with. But like we all know that Nigeria inherited its law from England. So at some point in England, there was a need to review this law because it was discovered that there were young people that are now started, they were involved in businesses, in commerce. And in order to encourage such persons to be more active in commerce, in economy, and in the growth of the society, there was a need to review the age. There was a need to review the age. And at that point, the age was reviewed from 21 years old to 18 years old. But that is not to say the fact that there are still some persons, there are still some under some things wherein people that are even lesser than that age will be approved to be, for you would vividly know that when it comes to, even before that, the advent of the review, anybody who is 18 years can vote, all right? Anyone who is 18 years can vote. And so also under criminal liability, people that are under 14 years, although people that are within the age of 14 and 17 are seen as young persons, but not seen as children. It's only people that are under the age of 14 that are seen as children. And so there could be a kind of varying, but when it comes to the law of contract, we are specifically speaking to the law of contract. And so subsequently, the rule from 21 years old was reviewed to be 18 years old. All right. So after that happened in England, because we most of the time look after the rules and the laws in England, there was also a need for such to happen in Nigeria. And so in Nigeria, we had the Child Rights Act, the Section 277 of the Child Rights Act, which then under that act allows, or the rule under that act stated that persons under the age of 18 would, within the age of 18 and below, would only be seen as children, as against the earlier, which says that persons under the age of 21. All right. So after the Child Rights Act, there was also a need for each state to enshrine this act in their own laws too. And so presently, we only have 34 states that has enshrined, or would I say that has adopted the Child Rights Act, and they made it their own law. And so amongst those states, or would I say some states that haven't agreed to that yet, or that hasn't adopted the Child Rights Act, Section 2277, are Kano and Zamfara. We are being, we are thinking that at some point, Kano and Zamfara will also follow suit and also imbibe or adopt this law as well. That is not actually to say that there are some law. When it comes to the law of Sharia, Sharia also has a way it defines who children are. All right, that it defines who children are. And so, in the case of Folake and Dowama, that's the case where a youth sold a family house. So in that case, it was held that under the Muslim law, which obviously would be the Sharia law, maturity is determined by its physical development and not only by the age, or a declaration of youth in question, where the youth in question declare that at this age, I see myself as being able to do some certain things, that I'm old enough. Or when that person reached the age of 15, and that age of 15 is read, or is calculated rather, under the lunar months. All right. And so, obviously, if Kano and Zamfara, we want to follow the Sharia law. So Kano and Zamfara would only approve persons that are under the age of 15 as old enough. And in fact, under Sharia law, with what we have seen, or would I say under the Islamic law, with what we have read under Falata and Dowana, those that have the physiques that an adult will have, like a female, if a female would have all that an adult female will have, that female will be seen to be as an adult, or will be declared to be a youth as against children. And so also it follows for the men too. And so they are seen as youths according to their physique. If physically they exhibit all that a youth would have had, then they will be seen as a youth. And so there comes this question. This question comes to play after the British review of the 12 to 18. And so the question says, in the reduction of age of majority in Britain and Nigeria, and that Nigeria beneficial or prejudicial to a child. I'll read again. Is the reduction of age of majority in Britain and Nigeria beneficial or prejudicial to a child? Will you advocate a further reduction, especially in this computer age? So I want you to put this in mind as we'll be discussing this in the class. Then looking directly or looking forward to our next slide. So when it comes to capacity of contracts, especially that of infants, we have categories. We have categories of contracts that are involved. We have contracts that are binding, voidable contracts, and we have void contracts. Excuse me. Contracts that are binding, voidable contract, and void contract. So let's start with contracts that are binding. So under contracts that are binding, we have contract for necessaries and also contract for beneficial contract of service. What I mean by contract for necessaries, they are contracts that are good and suitable to the condition of life of an infant and to his actual requirements at the time of sale and delivery. Take note of this definition very well. The first part of the definition says that they are contracts that are good, suitable to the condition of life of the infant. So anything that will be suitable to the condition of life of an infant. An example of this contract are contracts to purchase food, contract to get shelter, contract for clothing, etc. And so for such contracts, an infant will be seen as binding with whatever amount of thing they buy under such a contract. And so that contract will be binding on the infant. So subsequently, we also need to put into consideration the second half of that definition. The second half says, to his actual requirements at the time of sale and delivery. So he must need that time at the time. He must need that thing at the time when that item was delivered to them, when they bought it and when it was delivered to them. So, for example, I would say, if a child buys a clothes, a person under the age of 18 buys a clothes from the seller, and at the time when he bought that clothes, he already have such clothes that would be like 3 or 10 or 20, or would I say even 5, especially for children that come from humble background. If a person that come from humble background already have clothes, for example, already have 5 or 10 types of such a cloth, but buys it at that time from the seller, at that time under the law, that person doesn't require it. That person doesn't have an actual requirement for such clothing. And so there's probability that such a contract, especially when they buy it on credit or something, or they eventually say they don't want to go ahead with that contract again, the law will support them, and the law will say that such a contract is not binding on such a child. So it's also good to also put into consideration that such a binding or contract of necessary, it covers items which, though not strictly necessary, there are times that it may not strictly be necessary, but appropriate to the infant's financial and social status. And so the fact that a person who is a child, but then comes from an humble background, that their parents could only afford an allowance of 5,000 naira per month. What will be necessary to that infant will be different from an infant who gets 50,000 naira allowance per week. So that person who gets 50,000 naira allowance per week can afford to buy a wristwatch of 30,000 naira. And so if an infant whose allowance is 5,000 naira per week buys a wristwatch of 40,000 naira, there's possibility that such contract will not be binding on them if there's a case in court regarding it, because the court will look at the fact that they cannot afford it. And so the question that comes to mind is that, is it fair on the vendor who had sold the item for them? And what I will always say to people in my class is that if you are a vendor and you are selling to an underage, number one, it's good to ask of their ID card to ensure and to ascertain their age. And if they are underage, I think it would be good at that point to ensure that you get across to their parents, their guardian, or whoever will stand for them, so that you don't do contract with them and subsequently not be able to get your money from them. So going outside after necessary contract for necessaries, we then have contract for beneficial contract of service. And in most cases, this beneficial contract of service occurs in apprenticeship or schooling contract that you entered into with this university. If you can remember vividly, before you or after you gained admission to the university, you were given some forms to fill, and under that form, you would have ascertained the fact that, oh, I'm going to respect the rules, I'm going to do this, and also the school will also undertake to ensure that you are taught appropriately, that you are, all the necessary things will also be included, and there will be signature on the part of the parties. And so those are those are called beneficial contract of service. I said they are contract of apprenticeship or for you being in school now. All right. So the next is voidable contract. What we mean by voidable contract is that at the time when that contract took place, it will be seen as if that contract is valid. But then there's possibility that that contract can be made void. There's possibility for such a contract to be made void. And so examples of this contract are contract for lease, contract of partnership, or contract for the purchase of shares in a company. So if an infant leases a property from another person, that infant can at any time say they are no more interested in the contract and that they want their share back. that is acceptable under the law. They can also say at any time for contract where they are a partner to another person, they can decide to say, oh, I am no more interested in this contract. Excuse me. Excuse me. That they are no more interested in the contract. If that be the case, the position of the law is that that contract will not be binding on them anymore. And so they can collect or receive all they are invested in that company back. And this also goes for contract for the purchase of shares in a company. And so if all of this happens, there is possibility, there is room, according to the law, for the infant to say they are no more going on with the contract anymore. And so under the law, such a contract would not be binding on them again. Another thing is that it doesn't really have to be when they are within the age of an infant. It could also happen that after they have attained the age of majority, which in this case it should be 18 years, they can, within reasonable time, repudiate such contract. Now, if they within reasonable time repudiate, which means they could say they are not doing the contract again. If they do that within reasonable time, the court would agree, would accept it, and such a contract becomes void. But then the court says they are not expected to sleep on their rights. So if they say, oh, after 5 years, they want to repudiate that contract because they entered into the contract while they were 18, such will not be approved by the law. But then I need to inform you at this time that what determines reasonability will be determined by the court. All right. There are some cases where the court can determine that 2 years is reasonable enough. You know, it depends on the court. But at most times, what the court strives to attain is justice. That in every case, there must be justice. And the reason why the court is trying to protect this set of people is that they are vulnerable, and there has been proof over the years that adults have been taking advantage of this vulnerability of this set of people. And in any case, where the court sees that an adult has taken advantage of the vulnerability of this set of people, the court will always protect these people. But then that is not to say that this underage too, they can at times be smart, or they can at times want to be smart. In the case where they are trying to be smart, then the law will also come in to protect the adults, because the law is seen as a shield and not a sword. And so an infant cannot use it to hurt or to infringe on an adult, basically to misuse the law. But the best advice that I would give to you in this case is that it's better to verify the age of clients before you enter into contract with them. And so at times you begin to ask yourself, as an engineer, as a person who studied engineering in maybe civil engineering, mechanical engineering, there may be no reason for me to have a contract or to be engaged in a contract with an infant. Really, I would tell you categorically, anything can happen. Anything whatsoever can happen. And that is why we are teaching you this course, in order to guide you against anything that could affect you in the future. All right. And so that is for voidable contract. Remember that I said that voidable contract may seem valid from the beginning, but at some point it may become void because the infant may decide to repudiate the contract. So the next in line is void contract. What void contract means that this void contract is not valid. They are regarded as contract that will not be binding under the law. Contract that is not approved, is not acceptable under the law. All right, so we have under section 1 of the Infant Relief Act 1874. And the provision of the laws provides that the following contract, if entered into by an infant, are regarded as absolute void. We call it void ab initio under the law. That's a Latin word used for absolute void. Void ab initio. And the examples of these contracts are contract for the payment of money lent or to be lent. So you are advised not to lend money to an infant. When you lend money to them, the court will not protect you, but rather the court will protect the infant. Number 2, contract for goods that are supplied or to be supplied, which are not necessary. If you can remember the case of Labinjo and Abake, this is the situation of that case, where Abake, under trade, bought some items from Labinjo, but because she hasn't retained or attained the age of majority, the court in that case said that she's not expected. The law would protect her, and so she's not expected to pay back the money of Labinjo because Labinjo was trading with an infant. So an infant, if you supply them goods that are not necessary, remember necessary, maybe for business, it is not what they need for their livelihood, then at that point, such a contract will be seen as void ab initio. It has no effect, absolutely no effect. It's not binding on the infant. And the next one we have here is account stated, especially IOU. You know, IOU are like a paper that are signed at some point that, oh, if an infant works with a company, or, you know, that's what people sign in the company. When you work with a company and you like to borrow money from them, you like to lend money from them before your salary. It could be at the middle of the month. So for that, companies will give such persons an IOU. And when they give such a person an IOU, they sign it, and after their salary comes up, they reduce or deduct the money from them and give them the balance. So under the law, such an IOU is not approved under the law, and so it will not be binding on an infant. It will not be binding on an infant. So if an infant collects an IOU, it will not be binding on them. Now, I also want to inform you at this point, when as I've been saying that an infant can repudiate. Now, this is not to say that if an adult, he unknowingly entered into a contract with an infant, and so at some point when he sues the infant, he discovered that that person was still a child. That is not to say that the law cannot help, and that's what takes us to the place of restitution. Now, the instances where the court can help is where the infant borrowed money, you lent an infant money. Now, the places where the court can be of help is the place of restitution. They will say that the infant should restitute, especially when it comes to the place of necessaries. If after borrowing that money, they use that money to buy necessaries, all right, such a money can be retrieved back from them, can be repudiated, because it will be seen as contract for necessaries, all right? It will not be seen as void contract anymore. But then, if they actually borrowed that money, they didn't use that money at all, that money is still with them. If you are able to identify your money, the court will allow for restitution, and the court will say that the infant should return the money back to you, all right? But in the case where they have used that money to buy, maybe they use it to buy things that are not necessaries, you cannot repudiate such contract. You know, such a contract cannot be repudiated. But in cases where the infant obtained goods by fraud, and then they cease to be in the possession of those items. Now, the law under this rule is quite unclear. But then, like I said, the aim of the courts, the aim of the law is to bring about justice, right? So what the law would do in this case is, according to each case, when such a case is taken to court, the court looks at each case according to its merits, all right? And so that's how the court will go ahead deciding the position or the right thing under the law. Then, that is for infant contract of an infant. Subsequently, we have to go to contract for an insane persons. For contracts for an insane person under the law, a person who is mentally disturbed, who is of unsound mind, are bound by any contract that they enter into under the law. They are bound by any contract that they entered into, except in cases where they can prove that the person whom they had entered into the contract with knows that they are insane, and so you want to take advantage of their vulnerability. Or number two, where they are able to determine, or where they are able to prove that at the time when they entered into that contract, they were actually not lucid at that time. I hope you know that there are times that insane person can be lucid. I mean, they can be of good, they can be of clear mind at some point, right? It would have to prove that at the time when the contract took place, he did not understand the nature of the contract. That he did not understand the nature of the contract. If he's able to prove these facts or this position, then the law will protect him. Like I said, contract that or would I say a mentally disordered person entered into when they are lucid, such a contract under the law will be binding. Now, what it means is that they cannot come under this exception that I've earlier mentioned, because at the time when they entered into that contract, they are lucid. And I don't know what you're thinking in your mind. The question that comes to your mind is that, how can you determine a lucid period of an insane person? That would be determined by an expert, for example, a psychologist. A psychologist would have to evaluate him to know and be able to determine. They would also determine that also examination in court, especially under cross-examination, they would be able to determine if this person can be lucid or was lucid at the time when he had entered into the contract. All right. So, like I said, every other contract that they entered into, for example, contracts for necessaries and for goods and services that are suitable for his life, he will be binded by such contract. I don't know if one way or the other, at some point in time, you have seen an insane person buying food on the street. They need those foods to survive. So you cannot come back tomorrow and say, but I was mentally disturbed, and so this person selling this item for me, he had done wrong. So the position of the law is that they have not done any wrong, and that the insane person would be expected to make payment for what he had bought. The next one is drunken person. Now, you need to also know that everything that applies to an insane person also applies to a drunken person. So, any contract that is entered into, so where a person enters into a contract in a state of drunkenness, the contract is voidable at the option of the drunkard. What it means is that that the contract may actually remain valid. Remember, we're talking about voidable. The contract is valid, but then it can be void. If after the drunkard person came to his senses and he says he repudiates the contract. When he comes back to his senses and he says, oh, this contract, I don't want to go into it because this person was trying to take advantage of me, that can become void if he's able to prove in court that he was actually drunk and this person knows that he was drunk. This person knows his condition, but then he went ahead with the contract because he actually wanted to take advantage of him. At that point, such contract can be made void. It can also be ratified. What I mean is that if after I become, during the time, maybe it was at the beer parlor, and this person was drunk, and he heard around the table, at the table, that somebody wants to sell a property, and he signed a contract or he agrees to buy the property, and in fact, he has transferred the money. After he becomes okay, when he comes back to his senses, he can decide to say, oh, it's not bad, it's not a bad contract, I can still go ahead with it. He can ratify it maybe by signature or by word of mouth. He can say, oh, but it's not bad, even if I'd entered into the contract when I was drunk. At this point, I am saying that I still want to go ahead with the contract. But after he became okay, he says that, oh, I want my money back. I don't want to go into such, I don't want to buy that property again. Under the law, such a contract becomes void because he is seen to have repudiated the contract and the money is expected to be paid back to him. All right? So, that is for drunken persons. Now, let's look at corporations. Corporations are companies. And under the company and under the companies and then Corporate Affairs Commission, the position of the commission is that everybody, or would I say under the Company and Allied Matters Act, the position of the law is that every company has an objective. And so all the companies are expected to act or to function within their objective. So in a situation where a company functions outside of its objective, such a contract will be void. Such a contract will be void. And this is the reason why this is being discussed under capacity contract is because there are some persons, because they are directors of the company, and they know that whatever the company does, they are not binded, it's not binded by them. It is seen as if a company did it by itself. So a lot of the time, they try to do some things that are wrong. They do some illegal things. They try to do things that are outside the scope of the objective of the company. In a situation where that occurs, the company, the actions of the director will be seen as void. And so it will not be acceptable. It will not be approved under the law. And so the law will not protect such directors. And the essence of this is that the law is trying to protect the company so that people will not use the company as a means to committing fraud, as a means to do things that are illegal. So the company will be protected under such contract. And so under such a contract, the directors who had been involved in such contract that are outside of the objectives of the company will be made a corporate. They will be made liable for such contracts and not the company. Please, if you don't understand any of these things, ensure you write some questions down for us to attend to when we get to class, all right? So this is going to another section of capacity to contract, and this is for illiterate persons. This is for illiterate persons. So under the law, illiterate persons are protected. So the question that comes to mind is, who is an illiterate? is who is an illiterate. Initially, the definition, if you look at the definition of an illiterate under our Oxford or whatever under dictionaries, an illiterate person is defined as a person who cannot read or write. That is for under the general definition of an illiterate. That is not to say that at some point the law too has not fallen victim of this definition. But then over the years, there has been growth. And so the definition of an illiterate has been streamlined to mean a person that cannot read or write in a certain language. So the fact that a person is a professor of English doesn't mean they are literate when it comes to French, when it comes to other language. They can be a professor in English, but then they can be an illiterate when it comes to French, German, or any other language. I know with this definition, you will be able to confine an illiterate to just such a person. So the fact that an old woman who lives in the village, who can read a Bible properly, the fact that she cannot read an English Bible doesn't make her an illiterate when it comes to a contract that is conducted in Yoruba language. But then she becomes an illiterate in a contract that is conducted, written and conducted in English language. All right. So now an illiterate is now confined to the language of the document, the language of the document. Now, let's go to requirements of the law. What then is the requirements of the law when it comes to documents that are prepared in a situation where an illiterate is concerned? And so when it comes to law in Nigeria, our lingua franca is English, isn't it? Our lingua franca is English. So a lot of the times we use English as a basis of the right language in Nigeria. That doesn't mean if a party decides to draft their own document in Yoruba, doesn't mean that it will not suffice. It is still regarded, it will still be regarded as a document, as a contract, even if it's not in English. So these are the requirements of the law. Number one requirement says the person who drafted that document for the illiterates, in a document that the illiterate is part of, such a person needs to write their name and their address in the document. And the reason for this is that if in the future there is a legal battle regarding that contract, such a person can be called as a witness to come and ascertain the content of that document. All right. So that is the reason why that is. And under that requirement, we have that he needs to also include, after he had written his name and address, he needs to include that he was instructed to write such a letter and that he was instructed by the illiterate person to write such a document. All right. The illiterate person must approve him writing the document. Number two, that the letter or the document, it was fully and correctly represents the instruction of the illiterate. And so a lot of the times, it will be required, as it is under number 2 here, that they would have to read and explain the content of the document to the illiterate. And the essence of this is that it will ensure that the illiterate fully understands what had been written in the document and that it actually represents their instruction. All right. The illiterate person will also be expected to sign the document. All right. And also either they sign it or they mark it. So a lot of the times for some people that cannot sign, they use their thumbprint. And so they print, they use their, which a lot, it doesn't have to be a kind of fine signature. It could be a mark as well, like it is said here. It could be a signature or a mark or a thumbprint. All right. That is for the requirements of the law. If there's any question, ensure to ask in class, all right? So what then is the consequence of non-compliance to all of these requirements that I've just stated? If a person who has drafted a document did not follow all these requirements, what then is the consequences? Now, the requirements of the law must be strictly complied with. But in the case of non-compliance may not necessarily render the contract void, all right? It may not say that because a person hadn't complied with all the requirements of the law, it doesn't mean that the contract becomes void. Remember what we mean void. Void means it's of no effect. It is not binding on the illiterate person, all right? So these are the consequences. Consequence number one is, if the document creates legal rights in favor of the writer cannot enforce the rights. And so what this means is that if a person prepares a document, all right, and so after preparing the document, if the document was not read over to the illiterate did not confirm understanding it, and the illiterate did not sign or give a mark, put a mark on it, and after the court discovers that the contract actually favors the writer, at that point, the writer cannot enforce the rights, because in the mind of the court, it will be assumed that the writer purposely did not read it over or did not allow the illiterate person to sign it because the content of the document favors them. And so that is what the court would presume. And so that's why the court will say that if the document creates a legal rights in favor of the writer, then the writer, if they did not follow the requirements, will not enforce or cannot enforce such a contract. So the next one is, if the document creates legal rights between the illiterate and a third, it is enforceable by the third party if he can establish that the document contains the true intent of the illiterate person. Now, remember in this regard, the person who had written the letter or who had written the document is not a party to the contract. In a case where the person who had prepared the document is not a party to the contract, that contract will be deemed enforceable, but then the content of the contract must comply with the intention of the illiterate person. If they are able, if the writer is able to prove that, but after I wrote this document, I read it over to you, and you accepted, you agreed to it, and in fact, you had signed. If they are able to prove all that points, then at that point, such a contract will be enforceable. All right. Number C, consequences. If the illiterate person can enforce the document if he can call evidence to prove that what happened if he can call evidence to the effect that what happened at the time which the document was prepared by the writer. For example, where both parties to a contract are illiterates. Now, in a case where they are both illiterate and one of them is saying, I don't understand and I did not sign, or I did not approve of what was written here. If the other illiterate is able to explain to the court what happened at that time, or if the writer of that document is able to explain to the court what had happened. Remember, in this case, the writer of the document is not a party, is not a beneficiary of that contract. In the case where he's not a beneficiary of the contract, then, and he can prove that everything, he can prove the circumstances in which the contract took place. You could say, the day when this contract took place, I was there. If not for this person would not have entered the contract. You are able to explain the surroundings circumstances. Then at that point, the contract would actually be enforceable on the both illiterate persons. All right, that's if they are able to prove the circumstances in which that contract was signed. Number 4 of the consequences of non-compliance with the requirement as stated earlier is the contract will be enforceable against an illiterate person if he received some benefit from the contract, or if by his conduct to the contract, or if by his contract to if by his conduct to may be taken to have affirmed it in spite of the omission of the writer. Now, there are times that even after a writer had written a letter or written a document, maybe out of pressure or something, they were not able to read the document to the illiterate person. Or that after reading the document to the illiterate person, the person did not sign. The position of the law is now that if the illiterate person benefited or had benefited from the contract, he cannot come back tomorrow and say, but I did not sign this document, so the document cannot be binding on me. And so it means that the document was not read to me. The court in that kind of a case would determine the case according to the fact that he had benefited from it. And so if an illiterate person had benefited from a contract, that contract will be binding on him. It will be enforceable on him, even if the requirement of the law did not take place. All right? If there was no compliance to the requirement of the law, but that the illiterate person benefited from the contract, such a contract will be deemed as if it will be deemed as if it's a valid contract, enforceable contract. And the last under this topic, or under these consequences of non-compliance, is a penalty of 100 naira fine or 6 months imprisonment may be imposed on the defaulting writer. And so you begin to ask yourself, why 100 naira even at this stage? Now, there obviously has been a kind of review by different states. A lot of states has reviewed this act, but then we are yet to have by the review of that act, some laws have reviewed it to be like maybe 100,000 naira default, or I think 100,000. I'm thinking anyway, I don't have a confirmed position. But then generally, we are yet to have a law that will review this. So as it is now, it is 100 naira fine for every defaulting writer or 6 months imprisonment. You see how 100 naira is so much far. This has been a law that has been in operation for a very long time. So I'd like you to listen to this, internalize it, come up with questions for classes. God bless you and take care.